welcome everyone. Thanks for joining us this morning. Just waiting for a few stragglers coming in, but got more than half now, so we can get started. We're talking about directors' liabilities today. My part will not be directors at large necessarily, but I'm looking specifically at liability for trademark infringement and passing off, and contraventions of the consumer law like misleading, deceptive conduct and unconscionable conduct. Annie's going to join me later and she'll talk about how directors might protect themselves in a more broad sense through deeds of indemnity and insurance. A few housekeeping matters. If you have questions, you're welcome to put them in the chat box and we'll try and answer them a bit later on. And if you have any technical difficulties, I've been assured that we're recording it and you can get sent a link. So if anything goes awry, you'll be able to watch it later. So firstly, I'll go through the elements of each cause of action, the ones I'm focusing on. Misleading or deceptive conduct is a statutory provision under the Australian Consumer Law, so it's section 18, and it's fairly simple that a person must not, in trade or commerce, engage in conduct that's misleading or deceptive or is likely to mislead or deceive. So that's primarily in place as a consumer protection because the idea is we don't want them being misled or deceived. Passing off has specific elements that need to be shown. They're sometimes called the classical trinity. So what's required to prove a passing off is goodwill or reputation of the person claiming they have an interest in the goods, name or trademark. And there also needs to be a misrepresentation that's likely to lead to deception or confusion. And there also needs to be damage caused by the misrepresentation, such as like a financial loss, for example. Trademark infringement, when's a trademark infringed? It's governed by section 120 of the Trademarks Act. A person infringes a registered trademark if that person uses a mark or a sign that's substantially identical with or deceptively similar to the trademark that's registered in relation to similar goods or services. So there's specific meanings for substantially identical and deceptively similar, and that's been quite widely explored by the courts, and they have specific connotations. Unconscionable conduct is also governed by the Australian Consumer Law, sections 20 and 21. Similarly to misleading or deceptive conduct, it's couched as a prohibition on actions. Here it's against engaging in conduct that's unconscionable in trade or commerce, including in connection with supply and acquisitions of goods and services. The elements of unconscionable conduct were considered in a recent case, the second one we're going to look at today, and they've determined that unconscionable conduct, it's not necessarily limited to just taking advantage of someone vulnerable or disadvantaged, but they've given it quite a broad scope now to be essentially anything that's against conscience. The first case I wanted to go through with you today is #Burgers and InNOut Burgers, which is a full federal court decision heard on appeal. But taking you back to where it all started, InNOut Burgers are a US company. This is their logo. They're a fast food restaurant and quite famous for their burgers. Apparently, the celebrities famously eat these burgers at Oscar parties, at the after parties. And in the early 2000s, they really came to be quite famous and recognisable in the United States. And as well as Australia, but we'll get into that a bit later. So you can see the logo is quite distinctive. It's got the yellow elbow and then arrow and the red and white writing. On the other side, we've got Mr. Kagan and Mr. Saliba. So these are the people behind hashtag burgers. They originally ran their business as sole traders, as a pop-up restaurant in New South Wales. They had a bit of a success and ended up incorporating themselves as hashtag burgers and left themselves as the sole directors and sole shareholders. You'll see why this is important later. They're essentially seen as being the company. And the case, the thing at the heart of the case and how the trial judge began her judgment is what is the line between inspiration and appropriation. So she was trying to work out if Kagan and Saliba were inspired and did their own thing, or did they appropriate InNOut Burgers' intellectual property. So the original action was taken out by InNOut Burgers. The appeal was by hashtag burgers, and we'll get into that as well. So InNOut Burgers took action against hashtag burgers for the 3 causes of action that I've just taken you through, not the unconscionable conduct, just the trademark infringement, misleading, deceptive conduct, and passing off. This is how a lot of these claims are couched, by taking all 3 actions. From InNOut's perspective, what you envisage when you think of InNOut Burgers, they would say, is the signage, the yellow elbow, the red and white writing. The palm trees in some cases has been important, not the one that I'm looking at today so much, but some of the United States ones. Their palm trees were actually quite iconic as well. Of course, they would say that they're famous for really good burgers, and when you think of them, that's what you're going to think about. And they also present their burgers in a half wrapper that has the iconic logo on it. These are all important factors that they say have been somewhat copied by the hashtag burgers people. So in Australia, quite wisely, InNOut Burgers had registered some trademarks. It had its logo registered for restaurant services and hamburgers and cheeseburger sandwiches. They also had word marks for in and out burger, protein style and animal style. And these were items from InNOut's menu. So they did quite well. They had their registered trademarks, but they also need presence in Australia. This is also important because in order to keep your trademark in Australia, you need to keep using it to maintain it. They didn't have a physical store here, so they had to think about how they could show that they had a reputation here and a presence here. They had regularly hosted some pop-up restaurants, and they were absolute sellout events. They'd also advertised in magazines that were in Australia and sold some of their merchandise in Australia, just to name a few of the important things. So this presence in Australia is useful for establishing whether your trademark's been infringed, because you need to be using your trademark in order to maintain it on the register. But it was also important in establishing a reputation, which, if you remember back to some of the first slides, that's an element to establish passing on. And so these are their pop-up restaurants that they had in Australia, in Sydney and Melbourne. And you can see it draws a big crowd, which was really important in establishing that they had a reputation in Australia. There's lines that go round the block and round the block again. So as you can see, hugely popular. Back to the Australian little guys. I think I mentioned before, they were sole traders originally, doing the Funken Burgers, and they had these pop-up restaurants in New South Wales. That was in June 2015. They had some modest success there, wanted to enhance the business. So Saliba asked the graphic designer to make them a logo. But when he did this, he specifically said, "Can you make us a Funken Burgers sign like InNOut Burger. And he even provided, in case the graphic designer wasn't aware of InNOut Burgers, he provided the InNOut Burger logo for his reference. So following these instructions quite carefully, the graphic designer designed the logos you can see on the screen for Funken Burgers. So you can see they've got the same yellow arrow and they've got a thumbs up in place of the arrow, the same yellow elbow and the thumbs up in place of the arrow. And they've got the same white writing on the red background. So they tweaked it a little bit, but it's still overall looking quite similar. So having some more success off the back of using that logo with Funken Burgers, Callaghan and Saliba decided to continue the business, but they wanted to change their name to Down and Out Burgers. So now they're using the InNOut, which is even more similar to the In and Out. They started to use this name to promote their restaurant and fast food services. They were using a different logo, slightly modified again, so that there's no elbow, but there's an arrow now, and there's still the red and the yellow quite prominently in that logo. And that was on their Instagram, Facebook page and signage. They had a pop-up restaurant in Sydney, and their media release stated, "Sydney's answer to InNOut Burgers has finally arrived," totally ignoring the fact that InNOut had actually already had a pop-up store in Sydney by this point. And their media releases also cited that they had secret menu hacks, such as animal style and protein style. Now, any good InNOut connoisseur will know that InNOut has a unique menu and they call it their secret menu. So Kagan and Saliba are up to no good again by the look of it. Animal style and protein style, you might remember, were two of InNOut's Australian trademarks, and they're also really quite famous burgers on the secret menu. Kagan and Saliba continued their business, and in June 2016, their logo had morphed into this. So they've got a yellow arrow again. It's looking a bit more like an elbow again, and they've still got the InNOut part of their name. That's another sign there. And this is a photo taken at one of their pop-up restaurants. I think it was in Sydney. And you'll see in the bottom right-hand corner, it says, "Don't ask about the secret menu." So this is hopefully reminding you about something. And at this point, it gets InNOut's attention. So they engaged some Australian solicitors, Baker McKenzie, and their juniors were lucky enough to be sent down to do some market research at Down and Out store. So they went to the Down and Out restaurant, saw this on the blackboard, asked about the secret menu, and were told that they had some animal style and tiger style burgers. And then, hint, hint, that's essentially protein style, you know. So InNOut wrote to Kagan and Saliba. It wasn't an unfriendly letter. They weren't too harsh. They said, you know, it's really flattering you're copying us, but you've coming to our attention and they're our trademarks. You need to stop using them, please. Kagan and Saliba sent a reply in writing, likely without getting legal advice, because it was along the lines of, "Oh, yes, we know about you, and we know that animal style and protein style are your trademarks, but we don't use them." And this was quite contrary to what Baker McKenzie had discovered, and so was really unhelpful to their case, as we'll see later. Some of their case did actually turn on some evidence that Baker McKenzie had obtained, either by sending their lawyers down or through subpoenas to get the graphic designer messages and things like that. So that was quite integral to proving some of the actions that #burgers through Kagan and Saliba had been doing. Kagan and Salva carried on with their business. Despite receiving the letter, they changed their logo a little bit. Whether or not that was a result of getting the letter, we're not sure. Perhaps they thought adding the hashtag and taking out some of the dashes might help their case. In the end, it didn't. And they were still, operating quite successfully. So they incorporated hashtag burgers in about June 2017. Then it ended up before the court, and Her Honour's decision in the original proceeding was that the actions regarding the down and out business went beyond simply being inspired. There was found to be trademark infringement, passing off, and misleading or deceptive conduct. So before incorporation of hashtag burgers, so there was no company. So for the period of time that Kagan and Salva were operating as sole traders, they were obviously jointly and severally liable for their actions at that time. After incorporation of hashtag burgers, that company had liability, but also, perhaps surprisingly to Kagan and Salva, they were also found to be knowingly concerned and liable for that contraventions of the consumer law. So largely that was misleading deceptive conduct. However, they weren't found to be liable for the period after hashtag burgers incorporation for trademark infringement and passing off. The trial judge noted that although they'd made those small changes, which saw on the slide before, with the hashtag, that they were still similar enough to be infringing the trademark and passing off. So looking at why Kagan and Salva should have liability for the company's acts, the court took into account a number of findings of fact, and these were later used by the Federal Court on appeal to uphold that part of the decision. So Kagan and Salva were the only directors and shareholders of the company. They alone made decisions related to its management. They alone were entitled to the profits of the company, including any profits made from the offending conduct. And the company was seen, in effect, to be their alter ego. So just a structure through which they were conducting their their business, as they had been doing as sole traders before. And it didn't appear that the company had made any significant difference or change to the way they were running their business or making decisions about the business. So they weren't only closely involved in the operation, they were the only people involved. It was also the decision of Kagan and Salva to use the Down and Out name in its various iterations, and that was what was seen to be the essence of the torts, of the offending actions. So all of these things led to the trial judge saying, yes, you were knowingly concerned, and therefore any breaches of the ACL, such as the misleading or deceptive conduct, you're jointly and severally liable for. But despite all of this, she still didn't find that they were jointly and severally liable for trademark infringement and passing off. So the case went to appeal. It was actually hashtag burgers who instigated the appeal, because they tried to appeal against findings of liability for trademark infringement, passing off, and misleading or deceptive conduct at all. InNOut then cross-appealed, saying, well, we actually think all of that's correct, and also Kagan and Salva should be jointly and severally liable for the trademark infringement and passing off as well. So on appeal, the judgment was no reason to depart from the trial judge's findings, definitely liability for trademark infringement, passing off, and misleading or deceptive conduct, and the appeal was dismissed. As to the cross appeal, which we're more interested in today, the full federal court looked in detail at directors' liabilities for actions of a company and how that fits in. They looked at the JR Consulting and Drafting and Cummings case, And that said, in relation to this issue, that the director must be shown to have directed or procured the tort, and the conduct must go beyond causing the company to take a commercial or business course of action or directing the company's decision-making. It was also noted that there was an additional component of a close personal involvement required for the infringing conduct of the company. Although they were careful to note it was a case-by-case basis assessment, the situation here is not really uncommon to a lot of small to medium businesses. The owners might start running their business as sole traders, decide to incorporate as a different structure, maybe for tax effectiveness or asset protection, and they retain full control over the company and how the business is run. So it's quite common. So what the main question will be when looking at director's liability is what was the conduct of the director that was said to go beyond the proper role of the director and get into the realm of close personal involvement. So in order to interpret that, the court relied on root quality and root control technologies. They extracted from this case that a director needs to be so personally involved in the commission of the unlawful act that is just he or she that should be rendered liable. Where a director deliberately procures the company to do something for the purpose of causing injury to a third party, liabilities rightly should be imposed upon him. So that wasn't quite the case with InNOut and Hashtag Burgers, but so they weren't said to be deliberately causing injury to someone, but they were still found to be sufficiently personally involved that they should be liable for the company's trademark infringements and passing off as someone else. So also seen to be important is the director acting beyond their proper role as a director. This is where director's knowledge will be relevant, including knowledge of things like the acts that he's causing the company to do are infringing acts, as well as knowledge of, trade registrations in place, like the trademark registrations InNOut had, and also knowledge of acts being carried out by others. Taking all that into account, the appellate court's findings on the cross appeal were that Kagan and Saliba were joint tortfeasors to Hashtag Burgers conduct, and that covered not only the misleading deceptive conduct, but also the trademark infringement and the passing off. So their appeal wasn't successful, and the cross appeal was successful, making it worse for Kagan and Saliba in the end than the first judgment. So the court based these findings of the facts from the trial that we went through earlier, but just pointing out some of the important ones. They were sole directors. They were the only ones making management decisions. They were the only ones receiving profits. There was no significant difference in how the business was operated before and after incorporation of the company, and they were knowingly involved in the company's wrongdoing. These 5 matters taken together demonstrated that Kagan and Saliba had a sufficient close personal involvement to be joint tortfeasors with Hashtag Burgers. So they're saying their conduct went beyond the reasonable threshold of performing their roles as a director. The key factors for the court in reaching this conclusion were the lengthy period of time they'd conducted the business before incorporation of Hashtag Burgers when they were sole traders. They also took into account the written communication between InNOut and one of the directors of Hashtag Burgers, where the use of the where they denied that they'd used protein style and animal style because that was not really written on behalf of the company. The exchange between the graphic designer was also with the directors of the company, and that was taken into account as well. And although I said before, they weren't found to be dishonest or really knowingly causing harm to someone, but they were found to have actually actively encouraged confusion which would be things like the media release saying InNOut, the solution to InNOut is now here in Sydney. So the InNOut case, we'll leave that one there, that found Kagan and Sullivan liable for the company's acts as joint tortfeasors. So, but directors can also face penalties under the Australian consumer law if they're knowingly concerned in offending conduct of a company. It's also possible they can get disqualified as acting as directors. So Section 224 of the Australian consumer law outlines the pecuniary penalties. And if a court is satisfied that a person has contravened quite a long list of different provisions of the law, but relevantly includes Part 2.2, which is about unconscionable conduct, or if they've in any way directly or indirectly been knowingly concerned in the contravention of one of those provisions, then the court can order penalties as they determine to be appropriate. Section 248 of the consumer law. Again, there's a long list of provisions, but specifically relevant for our purposes is Part 2.2, which covers unconscionable conduct. And if the court's satisfied that that's been contravened, then they can justify a disqualification from managing corporations. So the case that brings this out is Australian Competition and Consumer Commission, or the ACCC, as we like to call it, and Quantum Housing Group. Let's really quickly run through the facts of the case. Quantum Housing Group was in the business of arranging investments. It was also an approved participant of the National Rental Affordability Scheme, which we'll call the NRAS. So it went out, entered agreements with private investors, and they would purchase properties from Quantum Housing in circumstances where the investors could receive part of the NRAS incentive. So it appears that all of this was above board. However, what Quantum Housing did was sent rounds of correspondence to their investors saying that they, in order to continue to get their incentives, they had to change fund managers. And they were recommending these approved fund managers, which were all entities controlled by someone called Mr. Fenn, and he was in cahoots with the Quantum Housing Director, Cheryl Howe. So the investors were really strongly encouraged to make this change and were actually told in the correspondence that they'd be in breach of their agreement and wouldn't get the incentive if they didn't make the switch. So at first instance, the first court hearing, these representations, they were found to be false and misleading, and the conduct misleading or deceptive in breach of sections 29 and 18 of the Australian consumer law. So on appeal, the additional ground of unconscionable conduct was also found to be applicable, which I went through the elements earlier. So in relation to the false or misleading representations and the unconscionable conduct, the director, Cheryl Howe, was penalised in addition to the company. So she was found to be liable as a director for the company's actions. And she was found to be knowingly concerned in its conduct. This was because, again, she was the sole director and secretary, and she controlled Quantum Housing. She was also really involved in the implementation and execution of the arrangements for sending out all the correspondence. She directed the staff and controlled the employees of Quantum Housing, and quite specifically, she had directed the staff to send out the correspondence. And the court thought that she should have ensured that the conduct of the company conformed with the law and appropriate standards of commercial behaviour. So she was held accountable for the company's actions. Even though she didn't gain any personal benefit, it was actually Mr. Fenn who was benefiting and actually driving the Quantum Housing offending conduct. So her penalty was $50,000 in penalties plus $10,000 towards costs, and she was disqualified from managing a corporation for 3 years. So interesting point to note is that section 224 of the Consumer Law wouldn't have applied if Ms. Howe had only been, if Quantum Housing had only been found to have been engaging in misleading or deceptive conduct. Hence, this is the importance of the broad finding of the broad meaning of unconscionable conduct, because that was within section 224 and meant that penalties could be applied. And it's also important to think of unconscionable conduct as an additional remedy and potential action if you're making claims against a company. So the takeaways from this are, it's a relevant consideration when you're on the side of defending a trademark or alleging that there's been a breach of the consumer law, that you might want to recognise if your opponent is in a situation where the directors might be seen to have an alter ego and be personally liable. But it's also, probably from most of your perspectives, it's important for directors of companies where they're in control of the entity and closely involved in decision making to realise that they can potentially be liable for acts that they arrange the company to do. So as directors, people want to be doing everything they can to protect against this. That will probably start with, conducting the company in a proper and commercially appropriate way, and obviously trying not to do anything wrong. But there's also other things they can do to help protect themselves, and Annie, my colleague, is going to go through some of the ways they can do this now.
Great, thank you so much, Amy. That was really interesting, and it throws up a lot of questions. The facts also seem to be extra juicy. That #burgers case, I guess, just like the burgers. So we hear a lot about directors' indemnities, but what really are they and how can they be used? It's what we're going to get into today. So to answer those questions, I'll start by asking a few more. And that is, who is vulnerable and who can be indemnified? What are the indemnities and what are the limitations to those indemnities? And then when should those indemnities be implemented? Where are those indemnities available? And why should the indemnities and limitations be considered? And also, how can those indemnities be implemented? So just a bit of housekeeping. In short, the answer to this question is that there are protections that can be afforded to directors and officers of companies, but they are subject to the limitations at law. For instance, a company, to such extent, as is permitted by the Corporations Act, can indemnify a director or officer. So we're going to unpack this statement a little bit more in this presentation. For the purposes of this presentation in particular, I'll just be referring to directors as an all-encompassing word to cover both directors and officers, except where it may be relevant to extend the definition to both. So we'll start with who. Directors' liabilities and indemnities affect both directors as well as the company, and can have some serious implications financially and socially. For instance, small to medium-sized businesses, as Amy was discussing, as well as larger corporations, should consider the advantages of entering into a deed of indemnity and access, and also obtaining some extra indemnity insurance. Sole shareholders and directors are at a higher risk in some circumstances, as it is easier to find that alter ego. There are no boards involved there. There are no other influences to hide behind. They have that controlling factor. And, also if you're looking at the length of time that they've been incorporated as well, there's lots of different factors that can throw up these issues and put you in a position you never thought you might be in. So it's always good to know. the alter ego, or the lifting of the corporate veil, as it's commonly referred to, does capture most of those small to medium-sized entities trading as a proprietary limited company. So what we'll do is look at, if you are caught as a close personal involvement, what can we do? So to understand why and what, we should appreciate what an indemnity is in itself. In short, it is a company that's undertaking to protect its directors against liabilities that may be incurred in the course of performing their company duties. It provides for a form of protection, in essence, and it promotes a safe environment for those people who are sitting as directors to undertake that position and to make some sometimes fairly tough decisions required to be made. If there were no indemnities, it may be difficult to secure some responsible people and personnel to sit as a director and consent to that position, as that will always be vulnerable. Also, it may only promote risk takers to sit in those company positions, which I don't think would be ideal either. So where a company indemnity cannot cover, there's also insurance, which should be considered. It's important for the same reasons. However, it gives a further protection and it minimises that financial burden on both the company and the directors, to the extent limited by law, of course, which we will go into a bit further. So if we look at why, their personal risks for assuming this position as director, so not just torts in infringement liability, as discussed by Amy in the talk just before, but it's also in relation to various forms of liability, which includes Corporations Act, Competition and Consumer Act, such as offences related to unfair practice, product safety and product information. It's very broad. We've got work health and safety issues, environmental laws, employment laws and taxation laws, and that's just to name a few. There's plenty more that we could probably drum up. But in a more recent change to this law has also occurred under the Treasury Laws and Amendment Combating Illegal Phoenixing Act, which was passed in 2020. This holds directors responsible for their duties as a company director until they lodge their resignation with ASIC, which then becomes the effective date. So in short, directors can no longer backdate this resignation. The importance of that is that directors actually remain liable up until the date that ASIC is notified. And so if any conduct occurs between that time you think you've resigned and the date they're actually notified, you can still be held liable for that conduct, even if you think you weren't acting in that position at the time. So it may be best, and we suggest that if you are looking to resign as a director, that you take on that responsibility yourself and you notify ASIC rather than relying on the company to do that on your behalf. That way you're in control and you know when that effective date comes in. So we'll look at how to have a company and director benefit from a deed of indemnity and or indemnity insurance. As you understand, their indemnities favour a company director to ensure that it provides that adequate protection. There should also be clear directions for each the company and the director to follow. So a director can be afforded the indemnities by three main protections. You're looking at, as we discussed, the deed of indemnity. There's also protections can be put into constitutions at time of corporation, and then also the directors and insurance, directors and officers insurance policy, which can be taken out on behalf of both directors and the company. So what we need to look at next is the deed of indemnity and access. So a company can indemnify a director for any potential personal liability, except for those prohibited under the Corporations Act, which is expansive and will be discussed in greater detail later in this webinar. So a deed of indemnity, in its essence, can offer three main protections. We're looking at providing for a director to pay for a portion of an insurance premium, which the company is prohibited from paying, enabling the director or officer to ensure that they are adequately covered by insurance. It can also allow for a company to make a loan to the director to cover the costs and provide a mechanism to offset any loan against the indemnity if the director is successful in defending that action. And also it can provide for a right of access to a former director once they've resigned to continue to review the books and records if needed to defend themselves from any action brought after they have resigned that position, or on the flip side, being terminated. We also have the insurance policies, which can be supplemented. So the insurance will indemnify a director for liabilities where a company does not or is not permitted to indemnify the director, or is not in a financial position to do so, which might be more common for smaller companies starting out, and also where the claims related to liability or prohibition under that Corporations Act section, which we'll look at later, and the company cannot interfere. So in relation to insurance, it can also be used to reimburse the company for the indemnity which the company grants to the director pursuant to the deed of indemnity. So, for example, to recoup any legal costs for which it indemnified that director. And it can also indemnify the company for claims in relation to its securities bought by shareholders. Sorry, just got distracted. Including alleged breaches of continuous disclosure or other market conduct requirements. So that third reason is probably more important, and I mention it because there are an increasing number of security actions being issued against publicly listed companies currently. Therefore, cover is becoming more important in their risk management strategy, and should also be looked at for smaller companies as well. So you never know when you may be hit. So we'll look at what this deed of indemnity can do, and the better question here is probably asking what it can't do, what it can't indemnify. So there are prohibitions to indemnities, and they include where a director owes a liability to the company itself, where the director's act arises from bad faith or omissions, or where a director's act arises as a pecuniary penalty or compensation order which arises out of a breach of the civil penalty provisions under section 1317G or H of the Corporations Act. So usually this is provided by way of declaration of convention, contravention pursuant to section 1317E, where a court is satisfied that there has been a contravention of either officer's duties, related party rules, share capital transactions, financial reports, insolvent trading, and others as listed under that Corporations Act. There are a lot to cover off. And it's a fairly large act, so if you like to read huge pieces of legislation, direct yourself there. But we'll try and just keep it to one particular section, which is Division 1, Part 2D.2 of the Corporations Act, and we're dealing with the prohibitions. So the prohibitions limit a company's ability to indemnify a director for certain liabilities or legal costs. The prohibited indemnities capture agreements set up by agreement or by making a payment, whether directly or indirectly through the interposed entities, and prohibitions to a company under this part also include a related body corporate. So it's good to keep those things in mind when you're reading through the sections. I'll also note that the reference throughout in this section to officer or part is defined broadly to include directors, secretaries, and also those who manage the corporations, and that would include receivers and liquidators. So the main sections of note, which are on the slide, do include section 199A1, and that has 3 subsections which we'll unpack. But section 199A1 deals with where a company cannot exempt a person from a liability to the company itself incurred as an officer or auditor of the company. So we're looking at, we'll look at section 199A subsection 2 just to give a little bit more context to that. And those indemnities apply to a liability. The company itself has discussed a liability for the pecuniary penalties and a liability that is owed to someone other than the company or related body corporate, so to a third party, from conduct which did not arise out of conduct in good faith, and good faith being essential there. So the concept of good faith is an abstract term that's not defined in an act or common law very well. However, it is generally synonymous with acting honestly and sincerely and having regard to the interests of the other parties, rather than, on the flip side, acting dishonestly, fraudulently or wrongfully. So the concept is derived from Latin term, which is bona fide. I've probably heard of that one before, and the court actually uses those two words interchangeably. So if you look at it, section 199A, subsection 3, we're looking at prohibitions on legal cost where defending proceedings either brought under the first subsection 199A1, where the director is found to be liable, where defending criminal proceedings where the director is found to be guilty, or where defending an ASIC or liquidator proceedings if those grounds, the orders against the director are established. So in relation to that ASIC concept, that they would include proceedings brought for an order under section 206C, D or E, which deals with disqualification of directors, section 232, which is oppression, section 1317E, D and H, which are those civil penalties, and also section 1324, dealing with injunctions. So just map out what those civil penalties are, the compensation orders under section 1317H, as well as the pecuniary penalties under section 17G. It's where you'll find most of those penalties. On last count, there were about 96 different pecuniary penalties, which can be categorised into three main areas. So we have financial services, and they focus a lot more on, say, banks and large financial providers. You've got corporate schemes, and then also you've got a third category just known as uncategorised, and that captures everything else. So some common ones that you would be aware of, you hear about them flipped around in newspapers a lot, would be breach of directors' duties, requirements of financial reporting, insolvent trading, avoiding employee entitlements, misstatement or omissions from takeover or compulsory acquisitions or buyouts, continuous disclosure obligations not being met, offering securities without a current disclosure document, obligations on disqualified individuals, insider trading, another really big one, contravening the passport rules, false and misleading documents, false information, breach of confidentiality of identity of whistleblowers, and also that victimisation or threatening of victimisation of those whistleblowers. So there's a lot to unpack in that, but there is a second section of this Act which is quite important to look at, and that is section 212, and in particular subsection 2, because it provides an opportunity for a director to seek that financial assistance from the company if the director cannot afford to properly defend themselves in the first instance. So the company may be able to give that person a loan in advance of, in respect of the legal costs that they think they'll incur to defend themselves. Section 212 provides that way for a company to assist a director in meeting those legal costs or indemnifying a non-indemnifiable claim, which was discussed up in section 199A, without that prohibition coming into line. So in short, what you need to take away is if section 199A does not apply, then section 212 subsection 2 will permit a company to make payments in respect of those legal costs. However, if Section 199A does apply, then that Section 212, subsection 2, permits a company to make payments, but the director or office then must repay that amount as a loan repayment. So in any event, for Section 212 to actually take effect, the benefit provided by the company would need to be reasonable, and reasonable is anyone's guess. It would be looked into in quite some detail, I'm sure. So the company can indemnify the director for these legal costs if the director is ultimately successful. It's a good takeaway in defending the proceedings. So if you really do think you're innocent, it's worth having that protection. So we'll look at Section 199B on the slide now, and that just prohibits a company from paying insurance premiums for directors where the conduct involved is a willful breach of duty in relation to that company, or where there is a contravention of Section 182 or 183. And the director, and this applies where the director must not properly use their position, that's Section 182, or use information gains from their position, Section 183, to either gain an advantage for themselves or someone else, or cause detriment to the corporation. So the duty continues after the person stops being an officer for the company, and that's important for reasons later. So what we need to look at is how does this affect some of the insurance premiums? The prohibition under Section 199A and B do not apply to a policy of insurance to cover legal costs. As such, a company can pay for a policy cover for legal costs for those matters, as well as legal costs for matters otherwise subject to the prohibitions against the indemnities, so irrespective of the outcome of that legal action. And a director should therefore ensure that directors' and officers' insurance is taken out on their behalf, and should carefully consider the scope of the cover to ensure that the potential liabilities and legal costs are covered to the greatest extent possible permitted by law. And just on that last section on the slide, I'll just make note that 199C is applicable, just to make it very clear that if Section 199A or B do not authorise anything, then that would be unlawful. So if it's not set out clearly, you can't argue that it wouldn't be covered. So just in summary there, we had a lot of questions at the start, the who, what, when, where, why and how. We're trying to answer some of those today. Who, where and why can be dealt with in one, but basically it's whether you're a small, medium or large company, director's indemnity deed and that indemnity insurance policy should be tailored to your company's needs, and it is a really important risk mitigation tool, and risk will always be there and it will always be different for any company and director. So it's worth having a look at the start to see where you may be liable, where you may fall into some issues, and sort that out as soon as possible. How? Well, by deed, by constitution, or by that insurance policy. However, companies undertaking to indemnify a director provides protections, but it will only be of use where the company has the funds in place to meet the liabilities incurred. So in this instance, that's where the insurance provides that additional support to that indemnity. And what? Well, an indemnity can cover anything that's not prohibited, in the short of it. And in reality, it is important to ensure that the deed of indemnity does not contravene any of those prohibitions on indemnities, and also of the payment of legal costs under Section 199A and B of the Corporations Act. So the heart of the prohibitions under those two sections is what they focus on, and it's also the conduct towards the company itself, or the conduct which is considered to be in bad faith or a willful breach. So that's what you're looking for. And the takeaway today is that the company may properly indemnify a director for a liability which is not motivated by some bad intention or a lack of good faith or by willful breach. So at DW Fox Tucker, we provide certain services and advice to directors and officers and also companies if required in relation to setting up that deed and indemnity and access, and also advising on insurance policies. These tools should be considered at the time of incorporation or when there's a new appointment of a director, and the scope of indemnities that we'll look at should cover acts and omissions. Also, it's very common for these indemnity deeds to cover a period of up to 7 years after that director has retired or been terminated, and that's because those risks don't disappear overnight, and it's always good to have that backup. So you'll see that our deeds cover topics including but not limited to indemnities and loans to officers and directors and officers' insurance and how that should be set up and who's going to pay for what, and access to records after the fact, conduct of claims and proceedings and how they should be approached, resolution of disputes and what happens in the first instance and last, and also, how does the communication work and what notices are required. So it's worth both a director and a company being on the same page on the available indemnities, and the parties should agree on the extent of those indemnities and access of documents and options before there's any reason to activate the terms and conditions of either that deed of indemnity or insurance policy. And as you can see, there's plenty to think about, but by starting on the right foot and getting a deed in place is a great way to safeguard yourself and or the company. And I think at that point we should wrap it up unless there are any questions. So there hasn't been anything that's come through. All right, we're happy to take the questions offline. So if something does come up that you are interested in discussing with us, you're welcome to send an email through. I think our contact details are provided. And we really hope that you got something out of this presentation today, and enjoy the rest of your day.